Jim Meseck. Thank you, Jim, for being on today.
Thank you, Jill. That was a very kind introduction. I think it would even make my mother blush. So, as Jill said, I'm an attorney. I represent a lot of professionals, particularly real estate brokers, mortgage loan originators, appraisers, and attorneys with respect to lawsuits against them for malpractice, as well as also with DORA licensing complaints. And then with respect to realtors, I often get involved with car grievances, whether that's commission disputes or ethics grievances. So when Jill asked me if I would speak, I first asked her, well, what do you want me to speak about? And she says, well, you tell me. And like, well, here, I will give you, the spectrum of the types of cases I see, the questions and calls I get on a daily basis, and maybe, and hopefully that will help you. You should know before I begin that I am not a transaction attorney. I'm not a regulatory compliance attorney. I am strictly defense. I only deal with litigation, complaints. So if you need a contract drafted or you want your policy manual reviewed, I'm not the attorney for you. I can send you to those attorneys. But if you ever find yourself facing a lawsuit or a licensing complaint, or you get called before CAR, by all means, let me know and I will be glad to help you. So obviously, as an attorney who works with real estate brokers, I am asked on a daily basis about COVID-19 and DORA licensing matters and what's going on. And I really want to congratulate Jill and Damien for being the friends of the industry that they are in setting up these calls, these conferences to promote education, to helping you stay informed. The best content that I've seen where I go to find answers for my clients' questions are to Damien, Scott Peterson, and of course, Marsha Waters, the director of the Division of Real Estate. Those people I find or have found to have been given the spot on advice and how we're going to get through this pandemic. So I get questions all the time about, well, what about this new order? Or what about this executive order? Or what about this publication from the Division of Real Estate? And it's great that you are staying on top of these things. You're attending Zoom conferences. I get reports back on whenever Director Waters speaks or when other attorneys speak or what's going on in the field right now. And it's going to stay, and it's going to have to be your obligation, your responsibility to continue to track what's going on. If you're not aware, last week, 1 week ago today, the Division of Real Estate came out with their Safer at Home guidance for real estate, in parentheses, a reminder, which again just goes over the guidance that's available for real estate showings. There's also guidance for short-term rentals, which you should be familiar with. So we're just going to have to stay educated, keep educating ourselves about what's going on in order to avoid getting in trouble with DORA with licensing complaints. So make sure you're familiar with the procedures for showing, for tracking, cleaning, disinfecting. If it's a rental, make sure you're aware of time frames, deadlines, being able to show compliance. For example, the guidance for short-term rentals says that you're supposed to leave the property empty for 24 hours before you even go in and clean. Right? And then there's guidance on what you need to do with cleaning, like removing soft materials like bedding, sheets, blankets, that sort of thing. And about what you need to do or be prepared to do in case somebody who is infected with COVID-19 stayed in the home. So stay current on the protocols, keep tuning in to webinars like this. Also, be talking with your team. If you are the employee broker, always be looking at what's in the policy manual, what needs to be updated. So I do represent brokers who have had complaints filed against them for showing homes during this pandemic. And what I'm seeing from the division, from the door investigators, is, if it's confirmed that there was a showing when there should not have been a showing, it's usually a warning, unless it's something flagrant, or if there's a second breach, then that will trigger even a more full-on investigation. And again, I get a lot of brokers telling me, like, well, Jim, I wouldn't have done it, but everyone else is doing it. And if I won't, someone will, or if I don't, someone else would do it. Okay, that's not a defense, all right? We need to be responsible professional industry leaders in showing that we are going to comply, that we're making every effort. We may have made a mistake, but we're going to fix that going forward, and showing that we're using this as a learning opportunity. Otherwise, if you try and make mistakes, or if you want me to come up with legal arguments, that's not going to solve the problem, and you're going to end up getting bogged down into a DORA complaint, where you're basically making yourself a test case. So the issue that they're looking at is competency and worthiness under CRS section 12-10-217 1Q. And that's where the concern is, and I'll just read it to you: having demonstrated unworthiness or incompetency to act as a real estate broker by conducting business in such a manner as to endanger the interests of the public. Obviously, public health is an interest of the public. So we have to show that we are not a threat to consumers, that we are not a threat to public health. And the way we do that is we show, here's the policy manual, here are the policies, here's how we're complying, here's everything we're doing to be in compliance. And we will be in compliance going forward. There's a discussion with the attorneys who also do the same work about possible other legal defenses, such as constitutional challenges regarding the extent of the executive authority to issue these orders. What are the limits under the federal and the Colorado Constitution as to what the state emergency powers are. But I can tell you, you do not want to go down that road, because the cost of that is going to be enormous. You run the risk of dealing with potential negative publicity, and that's what we want to avoid. I view my job as, I want to get you back to doing what you do best, and that's helping your clients buy and sell real estate. You do not want to be stuck in depositions or reading, briefs filed with courts. So again, the way we're going to get through this is compliance and moving forward in cooperation. So moving on, I know you spend a lot of time with the COVID-19 developments, but some of the other areas I see that have become points of emphasis with the Division of Real Estate and the Colorado Real Estate Commission are property management and transaction broker issues. So, that's the next bullet point on my list here, is the lament of the property manager. So there are so many requirements for property management, and people have a connotation or an idea in their mind of what property management is, and a lot of times it's very different than how the Real Estate Commission sees or views property management. For instance, a lot of people didn't realize that short-term rentals was considered property management, or like Airbnb, for example. If you're helping out an Airbnb client or through another platform, that's property management. You're receiving a commission. So that falls within the definition of practicing real estate. And then on top of that, there are random audits. And as an attorney defending property manager brokers from the outside looking in, sometimes they don't seem very random to me. For instance, if you did have a complaint against you, and it may be completely unrelated to your property management practice, you know, it shouldn't come as a surprise that you are randomly audited. Okay, so once you get audited, there is a bunch of forms with checklists, and you got to produce documents. And one of the things that is particularly an area of focus for investigators are accounting practices, bank accounts, and record keeping. So, you know, and again, with the accounting practices, there's more changes coming. You know, if you do any property management or anything like property management, make sure you have read Chapter 5 of the Real Estate Manual. Again, be on the lookout because the rules are going to be tweaked effective July 30th this year regarding new accounting practices with respect to trust accounts. So a lot of brokers who do property management don't appreciate the finer points. Sometimes they don't even get the bigger points. And so a lot of my job is educating these brokers on how to become compliant. For instance, you know, Rule 5.2 talks about trust accounts. Okay, you have to have trust accounts if you're going to be a property manager, and you cannot commingle. And there's several ways you can commingle. For example, if you have your own property that you are managing through your business and you were receiving money through your own brokerage account, you have to put that in a separate trust account. That cannot go into the same trust account as your clients. Okay, so that's a fine point that, you know, some brokers don't appreciate. So the concern by the commission as to why they want these different trust accounts, why it's so important for them that you don't commingle, why the account has the name trust or escrow account, is because if you ever got a judgment against you or your business, then that money belonging to the other people cannot be garnished or attached or liened against or seized. So again, they're looking out for consumers. And with DORA, as you know, they are all about consumer protection. That is their mission. That's at the top of their website. They live and breathe that and vigorously pursue that mission. So another area that I see brokers having problems with respect to property management are the record keeping requirements. A lot of property managers think that, oh, I can just use QuickBooks. No, that doesn't work. You must have a journal, you must have a ledger, and you must do a three-way reconciliation at the end of every month. Okay, and QuickBooks does not lend itself to that type of accounting. All right. Also, you have to have monthly reports going out or whatever is required under your management agreement. And what I see is a lot of property managers don't even know they need a management agreement. So we have to have them go hire an attorney to develop one. Also, the employing broker who may not even have any role in the property management, they're still responsible. So I have complaints where I'm responding if there's no conflict on behalf of the brokerage, on behalf of the employing broker, and on behalf of the broker who's actually doing the property management. Okay, and all are subject to licensing discipline. Okay, again, you know, one of the areas that has been an emphasis, at least from my viewpoint, is, you know, property management with respect to long-term versus short-term rentals. So even if it's a short-term rental, even if you're only obtaining the rental for like 3 days, you still have to follow all of those accounting, record keeping, and banking practices. And yes, Airbnb rentals is property management per the definition.
Jim, if I could just jump in real quick, 511 we talked about before. You obviously know the rule is changing July 30th, and I want to make sure that we're clear that the accounting requirements for your own personal property are going to be different. It's not going to be the three-way reconciliation that Jim is talking about. It's going to be two-way reconciliations. They've tried to dumb it down or decrease the onus on the brokers as far as your own rental properties. However, because of what the statute says, and because obviously the DORA or Division of Real Estate has a vested interest in protecting consumers, you do still have a trust account requirement for those security deposits, and that goes for short-term rentals as well. Anytime you're holding money of others, whether it's a real estate broker activity or not, you're going to be required to put it into a trust account. So keep in mind that if you're doing your own rentals or you're doing property management, there's really two sets of rules, and you need to be familiar with both of them.
Yeah, it's just an area loaded with pitfalls for the unsuspecting broker. And so again, it all comes back to educating yourself, being proactive, so that if you are ever faced with an audit, you can respond and show that you were being competent and that you were not putting consumers at risk. So another area that I've seen really become a focal point of emphasis is when the broker is acting as a transaction broker. And as you know, here in Colorado, you can be a buyer's agent, a seller's agent, and a transaction broker. And the duties of the transaction broker are established by statute. And there's also a commission position statement on point, CP 31, where you are directed to critically ask yourself, is this an appropriate transaction where I can serve as a transaction broker? The problem is that when a broker, especially when they transition from a seller's agent to a transaction broker, are they exercising the reasonable skill and care required under the statute? So are they advising the parties regarding the transaction? Both parties, the buyer and the seller, okay? Are they keeping the parties fully informed regarding the transaction? Are they assisting the parties in complying with the terms and conditions of any contract, including closing the transaction? And so it's a very hard line to walk consistently, trying to stay neutral, especially if you've been the seller's agent and switching over to working with both parties. A lot of the brokerages I work with, they have a flat black and white rule. You are either a buyer's agent or a seller's agent. They do not allow transaction brokers. So if you are going to be a transaction broker, which the law does allow, you must have a clear plan. You have to manage expectations of the buyer and the seller, and you have to document exactly how you complied with the statute. Anything short of that, and you're taking a risk. The next thing I want to talk about, which I see all the time, is frivolous claims, frivolous lawsuits, vexatious, meritless, lacking substantial justification. Damien, I'm sure, filters many, many more that I don't even see. But this is the United States of America, and anybody can sue anybody for anything, and they do, including real estate brokers. And you will be sued because, if for no other reason, you have E&O insurance, which you're required to carry by law. So I often get asked, what's the most frivolous claim I've ever seen? And so it's a tie. And so when I do these conferences live, I'll take a poll. I'll describe the two most frivolous cases I've ever seen. And actually, I think, Damien, you were connected to both of these.
I know I was. I'm pretty sure I was connected to both of those. And Jill, you can put up the poll if you want. I think I don't know if she can do that or not, but.
Yeah. So Exhibit A of the most frivolous lawsuit I've ever defended is what I call the water runs downhill case. And what had happened, this was in south central Colorado. There was a development on the side of a mountain, and my 80-some-year-old real estate broker client, she lived in that development too. And we have a guy from Denver who decides he's going to, move away from the big city and live in the country. And in 2015, there were these heavy rainstorms that came through Colorado, including the location where the home was. And, the rain fell, ran down the side of the mountain, washed away the gravel around his home, the decorative gravel, and some got in his garage, some got in a crawl space. So he sues. He sues the seller and the seller's agent for not disclosing that water runs downhill. Your second option, Exhibit B, is some versus many golf balls. So I had a broker who listed a home on a golf course. The hole, the pin, was close to the backyard of this home. The seller put in the seller's property disclosure, some golf balls hit the home. And this guy was actually a golf pro. In fact, he wanted the home because of its location, the golf course. He could see the dents in the siding and on the roof where the golf balls had hit. Well, he buys the home, the golf season comes, and now he turns around and sues because there were way more golf balls that hit his house and were a threat to his children. He couldn't let them go out and play in the front yard. And then even if they went in the front yard, they still got hit. So he sued because we didn't disclose that there were a lot more golf balls that hit the house, or way more than he thought than just some. So we're litigating over what some versus many.
Jim, wasn't that the one where he also claimed that the kids had to be in the yard wearing helmets or something every time they went outside?
Yes, yeah, they couldn't ride their bikes in the driveway in the front of the house and all that. So, it still costs to defend the frivolous case. And so even though these were ridiculously frivolous cases, the insurance company settled both of these claims for nuisance value. And so a lot of my day is spent arguing over nuisance value for these types of cases. And I get the question all the time from brokers about, well, why does the insurance company do this? Why don't they put up a fight? And it comes down to economics, just the business side, okay? We can make these cases go away sooner, faster. If we litigated every case, you would never get anything done. Like I said, my philosophy is getting you back to doing what you do best, selling real estate, so you're not having to deal with attorneys. And you got to realize that part of the decision process is taken out of your hands under the terms of your insurance policy. You still have a consent provision. I cannot settle a case or make an offer or accept an offer without your consent. And I think I'm required to always have it in writing too. But, this is the modern era of the way our civil litigation system works. So, if you do get hit with a lawsuit, it's okay. There are attorneys like Damien and I and some other people here in Colorado who focus on defending real estate brokers, and they will take care of you and get you through it. Okay. So I often get asked about, well, what are the unusual cases you get, or what are the typical cases you get? You would be surprised about the number of cases involving animals, vermin, nuisances. I've had cases involving rats. Straw bale houses are just like rat magnets. So if you are ever listing or have a buyer interested in a straw bale house, you absolutely should be recommending that they get an inspection.
Jim, why don't you explain what you mean by that, what that is?
Sure. So it's not typical here in the Denver metro area, but outside metro areas, homes are constructed out of straw bales. So the walls are usually thicker, and instead of insulation, they use straw bales stacked on top of each other all the way around the house. Okay. And so rodents like to get in, especially in the wintertime, and burrow into the walls to get to the straw where they have their nest. And so I had a case in, again, this was in southern Colorado, mountain community area, with a straw bale house. And my client was the property manager. And one of the tenants had even complained about, a rat getting into her bedroom while she was on vacation and gave birth. And she came home and found the nest of baby rats. And then they were always calling out exterminators to put poison around. And so the way the poison works is the rats eat the poison, and then they go off into the burrows and die. Well, they didn't disclose any of this. Buyer buys the house, starts smelling something bad around a vent, opens up the wall around the vent, and finds literally 2 feet all the way around of rat carcasses, years of collection. And of course, was not happy about this. So, I had another case where there was a snake den in the wall of a home that backed up to an open space down at Highlands Ranch. Thankfully they were gardener snakes, but I've had cases with, mice, and, the buyer moves in and finds, like, why are all these traps laying around? Why is there just a box of poison in the back of the closet? And it turns out mice. I had a case, I didn't represent the broker on this one. I actually represented the exterminator up around Longmont, of a really nice home, but it was just like the bat cave. And they were like literally inside the walls, like 3 feet of bat guano. So it's just, that's one of the fun parts about my job, is just, the new interesting ways that people think brokers are at fault or should know about this stuff. The most common fact pattern I get, though, of why brokers are being sued, and this is buyers and sellers brokers, is because they don't know or unfamiliar with septic system requirements for the local jurisdiction. I get at least half a dozen septic system cases every year. And that includes both DORA complaints and lawsuits. We try and get those, the septic system cases resolved before it gets to litigation, because usually, the money we're talking about, depending on the type of septic system, is $30,000 to $40,000. So the problem is, it's usually brokers from larger cities who have never dealt with a property with a septic system. They have a buyer who wants to go out to the country. The home has a septic system. They come from a jurisdiction that doesn't have septic system, transfer requirements, inspection, permitting, and they're unfamiliar with the area or the issues. And then the buyer buys the home, gets in, and all of a sudden the septic system isn't working anymore. So then they find out, well, hold on, there was supposed to be an inspection, there was supposed to be a permit. Now it's not in compliance. Now I got to go hire an engineer. Not only do I have to repair it, but I got to permit it, and there's always the threat that the property could be red tagged. So again, if you have any property where there's a septic system, start asking questions. What are the jurisdictional requirements? A lot of people think, well, the title company should know this. It's like, they don't. So don't rely on the title company. Be talking to your buyer, know what's going on in your jurisdiction. Another part of the problem is, people think septic system permits, oh, that's with the building department. That's not the case. It's with the Department of Health. It's the local, like for Douglas County, it'd be the Tri-County Health Department, or Boulder County Health Department, or Jeffco county health department. And so it's not intuitive, and people don't think, what happens with that water when it goes down the drain in the shower or you flush the toilet, it just goes away. Well, it has to go somewhere. So, but I want to keep moving. I want to leave some time for questions here. So another common trap for brokers I see is broker-owned property transactions. That's with the broker acting as their own seller's agent when they are the seller. Okay, so one of our main defenses when I defend real estate brokers is the statute requires that you have to disclose adverse material facts of which you have actual knowledge of. Okay, so I can make that argument when you're wearing a single hat as the real estate broker. It's really hard to make that argument when you're wearing two hats, as the listing agent and as the owner of the property, because you're presumed to know everything about the property, probably even before you're expected to know the history, and then obviously what you did with the property. A lot of times I have brokers who get themselves into trouble when they do a fix and flip and they don't get the permits and they don't disclose that the work was not done with permits, or that they hired a contractor and the contractor didn't get permits. Not only did he not get permits, the work was not compliant with the building code. Also, there are HOA issues. So, we're at a time where a lot of the development that happened in the 80s and 90s with HOA communities, when they originally built the roofs, the siding, the concrete, all of those things are reaching the end of their useful life when they were built back in the 80s, 90s, 20 years ago in 2000. Okay, and special assessments are becoming more and more common and frequent in HOAs. And so the broker owner, even though you don't go to the monthly HOA meetings, there's still minutes and you're expected to know what's going on in your HOA. And yeah, you may not have actual knowledge, but you have presumed knowledge because you're supposed to know. Also, problems with zoning, boundaries, easements, where just because you're the owner, it's really hard to defend those, saying, well, you didn't really know about it, even though you own the property. Just moving on real quick.
Jim,
Yeah.
Jim, before you move on, I just wanted to point out something because you brought up a good point with these broker-owned properties. And I think it's important for the people on the call to understand that your E&O doesn't always cover you for broker-owned properties. In some policies, it's an add-on. Sometimes it's allowed, sometimes it's not. I mean, and sometimes they have requirements that you have to meet certain things in order for you to have coverage. So, aside from the fact that they're dangerous, and that's the reason the insurance companies ask for more things on their policies, you may not have coverage, and you really need to know what your exposure is when you get ready to sell one of your own properties.
Yes. So, one of the point number 10 on my list was broker insurance needs. And if you are selling your own property, I highly recommend that you look into getting additional coverage under your E&O policy. Well, first of all, like Damien said, make sure you have E&O coverage, that there's not an exclusion for broker-owned property. Get additional coverage. Also, if you're doing fix and flips, you should have what's called a commercial general liability policy that covers you or your business personally for construction defects or issues that could come up with the fix and flip. So, it's very much worth your time to talk about with an insurance broker these sorts of issues. Also, I would suggest getting an umbrella policy on covering everything on top of that. I have an umbrella policy that covers my auto, my home, and my work, even though, my firm obviously has insurance. But yeah, this is a huge issue. And so many times I've seen brokers get in a spot where they're you're being sued as both their listing agent and as the seller. And the insurance company has a duty to defend, but they're not going to pay any judgment against you as the owner. That can be separate and distinguished from you as the broker. And then you get into coverage disputes, and I can't get involved in those. So everybody lawyers up even more. So it's best to be proactive up front. Try and get a CGL policy that covers you or your business if you have an LLC that's doing these fix and flips for such things like construction defects. So just quickly, I'm stealing this from Eric Romero from Your Castle of his quip about no favors for anyone. So this is another area where I see brokers really finding themselves in trouble, is where they go beyond and above what's required. So as you know, the statute for buyer's agent or seller's agent, there's no duty to investigate the property for the benefit of the buyer. There's no duty to verify the representations of the seller or an independent contractor. However, over and over again, I have brokers who, want to be the professional, want to, go above and beyond, who volunteer and take on investigations, who I will go look and verify if what the seller's saying is true. They will go to the local zoning board, and then they get partial information, or they try to summarize the information, and not everything gets summarized correctly. Not all the information gets produced. And now you've created a duty for yourself or an obligation where you didn't have that duty before. And now you have that extra liability. So, when I first started working with David and doing the real estate broker defense work, it was in 2007, 2008, when we saw just rampant fraud. I'm not seeing that anymore, but the problem I'm seeing is brokers are too nice. They want to do a favor, and they have a hard time, honoring those boundaries of, this is what you hired me to do. Okay, this is what I can do. Okay, and they want to be everything. Try and be everything for their client, and that's just a bad move. And it comes back to bite them. So no favors for anyone, or if you want to say no good deed goes unpunished, or whatever other cliche you want to use, just, be very careful in what you agree to do. Try to stick to doing what is expected of you under the uniform duties in your contract, your listing contract, and under the statute. Just real quickly, I know we want to get to questions. Another problem I see with brokers are mineral and water rights. Anytime there's a discussion or the word mineral rights or water rights are brought up, you have to tell your clients to get an attorney. Okay, because it becomes a huge problem when it comes to reviewing deeds and contracts and describing those reservations. And title companies, even though they're hired and you expect them to understand these things, don't always understand it themselves. But a lot of times, yeah. So, and water rights are tricky here in Colorado. It's a highly specialized area of law. I would not feel comfortable, drafting a deed involving water rights. All I know is that water rights are sold by way of stock certificates. And I know that there are 2 water stock exchanges in Colorado. One is in Fort Collins, and I think the other is in Greeley. But the value...
And you know that water runs downhill.
Yeah, and I know water runs downhill, yes. I've got the case to prove that. So get an attorney. All right, moving on really quick. So when do you get an attorney involved? Well, obviously, if there's a specialized area or issue like mineral rights, water rights, get an attorney. As soon as there is a dispute between the buyer and seller about the contract, I want to see that email in the transaction file saying, I advise the client to consult with an attorney. This is now a contract dispute. This requires legal advice. You know, and here are the names of 3 attorneys, or they have their own attorney. Another area where attorneys are needed are deed descriptions. Again, especially if it's involving water, mineral rights, or if they're trying to carve out or subdivide parcels. If you are working with an estate, you're going to need a personal representative deed prepared by an attorney. This is another area that I'm surprisingly seeing more and more cases of, are cases involving elderly buyers and sellers, where later on after the transaction, the elderly person is declared incompetent, or they have a guardian assigned, or a conservator. And I'm ended up defending my clients for such claims like elder abuse. Okay, so you know, if you have any concerns about a person's health, competency, wherewithal, you got to get them to an attorney, and you got to get a letter that says they're competent. And that may also require a healthcare provider as well. A lot of times I see claimants wanting to use the DORA licensing complaint process as a way to build their case. So if you suspect that litigation is coming, and you have a DORA complaint already, you may want to get an attorney and look at what your insurance policy says as far as what they provide. Some policies will provide a limited amount that they'll pay for an attorney to represent you. And then obviously, if there's going to be an E&O claim, get the insurance company informed right away too, so that they can start working with you on that. With the car ethics grievances, they really don't like it when the attorney walks in the room. At least that's been my experience. Maybe it's just me. They really want to hear from the realtor, and they want to talk to the realtors together. But you know, some people, some broker realtors feel more comfortable with an attorney. They want to be prepared by an attorney. They want to have the documents submitted on time, make sure all the I's are dotted, T's are crossed, all those things. Make sure that all the arguments have been presented. And I get that, but I can tell you, it's like, whenever I walked in the room, I get the eye roll and the sigh, like, who brought the attorney? So, you know, you have the right to an attorney. It just may not be to your tactical advantage to show up with
Sometimes it's helpful to have the attorney kind of help you plan out your defense, but maybe not have them go with you. Because I had the same experience, Jim, that, you know, I mean, it's a bunch of brokers. They want to hear from brokers. They don't want to hear from lawyers. They want to beat up on other brokers.
Right.
But, you know, helping them lay out their case might be helpful.
Yeah, so the last thing I want to talk about is over-reliance on technology, and you can't be too careful. You know, I get, you know, 2 or 3 cases every year involving cyber fraud, where somebody's email got hacked and the unsuspecting buyer ends up wiring their money to some criminal overseas, and the money's gone. And these claims are getting bigger and bigger. You know, 6-figure type claims of money that gets lost. Another common problem I see is over-reliance or over-trust with the CTM e-contracts. CTM e-contracts are a wonderful tool. I mean, I'm very thankful we have it. It's so much easier to use the forms. However, they're not foolproof. Where I see brokers get in trouble is when they cut and paste from their last contract into the new contract, and they don't change the dates, or they forget that they have the auto-populate set for this type of transaction and use it in the same one, or where multiple offers are sent to the seller at the same time, and the seller accept, and I'm paying somebody not to buy a house. So be careful with CTME contracts. Technology's great, but don't let it come back to haunt you is my advice. So do we have any questions? One other point about insurance.
Yeah, could you go through the insurance a little bit, Jim? Because I think this is important. I don't think people realize that not all insurance is created equal.
Right. So there are several different insurers that provide E&O insurance products here in Colorado. You really need to study them. There are insurance brokers that Damien and I can refer you to who can help you. You need to know what's covered, what's not covered. You need to know if, am I covered by a group policy? Do I have my own an individual policy? You need to know what your independent contractor agreement requires of you with respect to providing your own insurance or indemnifying the brokerage, employing broker. You got to know what's covered as far as your team. Is that going to cover the acts of the unlicensed assistant? Is it going to cover, anybody else who was on your team for a short amount of time? You got to know if you have an occurrence-based policy or a claims-made policy. And what I'm seeing now is with especially the boomer generation is that when they retire, they think, oh, I'm done with real estate. I don't need insurance. I'm not working anymore. Why would I pay for that? And they don't realize they need what's called a tail policy. And a tail policy can be important because if you retire, and you get sued, a year and a half after you retire, you do not have any insurance at that time unless you bought the tail policy. Okay. I also see brokers getting in trouble when they switch firms and they don't know what policy covers what. So if they have one type of policy when they were at brokerage A that only covers claims made during that period, and they switch over to a new firm and they have a policy that only covers claims made going forward, they could find themselves in a position where there's no coverage from when they were doing a transaction at brokerage A. So also, when you go inactive, make sure you still have E&O insurance. Just because you're inactive is not going to stop the seller from suing you from that transaction you did just before you listed your license as inactive. Again, make sure you know the difference between group and individual, what's covered, what's not covered. And again, I cannot stress enough how important it is if you were listing your own property to make sure that you have coverage for you as the seller in addition to your E&O insurance. And also, I always think it's a great idea to have an umbrella policy. So I think I've gone too long, Damien and Jill.
Yeah, I think we're right on the edge. I just want to add with the insurance that people should be looking at the possible endorsements they can add on. There's a whole bunch of endorsements. We talked about this with COVID, about bodily injury and property damage not typically being covered, and a lot of times that's an add-on of different policies. And guys, you should be paying attention to what endorsements you want, whether it's property management, business brokerage, your own personal residences, bodily injury, property damage, whatever. Just make sure you know what your policy covers, and that you don't just think, oh, I got my coverage, I'm good. I mean, there's more to it. But I'm sure Jill has a ton of questions for you, Jim, so we'll let her go ahead and ask away.
Okay.
Yeah, we've got a lot of great questions. Great presentation, Jim. Thank you. That was really interesting. Let's just start here. So how long to keep a tail policy when making these changes? How to get coverage for yourself as the seller? Is this an additional endorsement?
Okay, so first question, how long do you get a tail policy for? My advice is get it as long as you can. Okay, so yes, here in Colorado, we have statutes of limitations. So it's a 2-year statute of limitation to bring a professional malpractice claim. However, that statute of limitations doesn't begin running until the claim accrues. And under the definition of accrual, that means at the time that the plaintiff knew or should have known or could have known of the claim. So, what we saw, especially with the heavy rains that we had in Colorado in 2013, 15, I think 2012, was that we had flooding in places where places hadn't flooded before. And so I had claims with people who were in the home for anywhere from 3 to 6 years, home flooded. They sued the real estate broker because the broker didn't disclose water runs downhill. Okay. So, you know, again, try and get it extended as far as you can.
I think the most tail policy you can get is probably 3 years. You could always keep your current policy in place for a number of years and then do a tail as well. But I think 3 is the max, isn't it, Jim?
I think so. I've never seen anything more than 3 years, but, try and get it as far as you can. If you can find it for 5 years, go for it. It's money well spent, peace of mind. You do not want to spend your golden years in litigation. So, especially if you're
paying for it yourself.
Right. I'm sorry, Joe, what were the other questions?
The second question was regarding getting coverage for yourself when you're a broker seller. Is there an additional endorsement, or what does that look like?
Okay, again, usually that looks like going out and buying what's called the CGL policy, Commercial General Liability Policy, where you have an LLC or a business entity set up to renovate homes, do the construction, the fix and flips. That will cover that. I don't spend a lot of time looking at my clients' insurance policies because of the ethics that go into what's called the tripartite relationship. So the tripartite relationship is the insurance company, the insured, and then the insurance company's retained attorney. And there are very definite rules that the attorney cannot advise the insurer or the insured on coverage issues.
How about I try?
I'm sorry?
How about I try?
Yes. So this is where it's advantageous to have a counsel on retainer or personal private counsel who can look at those issues and advise you.
And I'll say real quick, Jim, if I could, just on those because I think this question probably comes to, I live in my home and I'm getting ready to sell it as a broker. What do I need to make sure I have coverage? Not necessarily the fix and flippers.
Oh, okay.
Great concerns about the CGL policy, which I think is important. In that case, every policy is different. Some have it included, some don't have it included. Some have it included if you do certain things like get a home warranty and an inspection, or have people waive them. Others don't have those requirements. Others have limitations on coverage. It's an insurance company by insurance company basis that you need to make sure that you know what your coverage is and look at your policy. If you're planning on selling your home when you're in the year that's coming, when you're binding your policy, maybe that should be one of your considerations as to which company you choose.
Agreed.
All right, here's another question. If an agent has individual E&O coverage with a $1,000 deductible, as well as the required group coverage their brokerage requires with a $10,000 deductible on standard transactions and a $20,000 on personal sales, and an issue arises, which policy is in play? Can the broker elect to use the one with the $1,000 deductible, or do both come into play?
Potentially both. It depends. So in Colorado, when analyzing coverage issues, the courts will always start with the four corners of the complaint. They will look at what's been alleged in the complaint. Is the complaint just focused on the broker? Is the complaint focused on the broker as the seller? Or is it focused on the brokerage, the employing broker duties? Are they alleging vicarious liability? So what the respondeat superior doctrine, where the master is always responsible for the servant. This is always a gray area in my mind, at least, as to whether real estate brokers or truly independent contractors or this kind of hybrid independent contractor employee. But potentially both policies could be in play, but it's going to depend on, how the complaint is structured and what's actually alleged in the complaint. And then it comes down to what exactly the policies say, what's in the independent contractor agreement. So, it's a good question, but in order to really answer it, you got to know a lot of the details.
Okay. What is the statute of limitations on property disclosure complaints?
Okay, so there's a couple claims that can arise out of a non-disclosure case. So there's the professional malpractice, which is 2 years from the date of accrual. There is a 3-year statute of limitations for fraud, concealment, and also, I think, negligent misrepresentation. So it's going to either be 2 or 3 years. It could also be 1 year for like defamation of title or slander of title, but I'd have to go back and look at that. Breach of contract, that could also be 3 years.
So in selling your own property, what is the best strategy? Just have a fellow agent list the property. And then there's kind of a second question that goes along with that. If I list my property with another broker, what is the extent of my liability that is different than that of a seller?
Okay. All right. Yeah, so the best strategy is to have somebody list the property. I would not make it your best friend or the guy, your office mate next to you. I would make it somebody who you trust, who's competent, who you would, other than yourself, would recommend to a client as a real estate agent. And you would also need to keep your employing broker or supervising broker informed. A lot of times, brokerages will have a policy manual provision that addresses the situation and will have their own internal policies on how to handle that. So again, you want to document everything, that this is not just a straw man puppet broker, that they understand that the person you retain as your real estate broker is going to have all the duties, all the obligations, and they're going to perform that, and it's not just rubber stamping what you do. So that's the way I would handle that. What was the second part of the question again?
Second part was, if I list my property with another broker, what's the extent of my liability that might be different than just a traditional seller?
Okay. Well, you do have the liability of the traditional seller. So in Colorado, sellers not only have contractual duties pursuant to the right to buy and sell purchase contract, the form contract. In Colorado, there is a tort duty for sellers to disclose latent defects that's non-delegable. So just because you have a broker and they're totally independent from you, does not relieve you of your contractual duties, depending on what boxes are checked or what's marked off in the form contract. And you definitely have a non-delegable duty as a seller to disclose latent defects. So disclose, disclose, disclose.
This broker says, I own 2 separate rentals with separate checking accounts through Wells Fargo. I just set up a 3rd checking account and called it rental escrow account and transferred the security deposits for both of these rentals to that new shared rental escrow account. I'm assuming this covers my bases for the new Rule 5.2 beginning July 31st.
I hope so. It sounds like you've got the correct name for the account. It's going to depend on, the actual accounting procedures of where the money's coming into the account from, where it's going out to. Sounds like you've got things right, but again, follow up, get more guidance, get more education from the upcoming. I think Director Waters is speaking regarding these changes on June 23rd.
Yeah, I think so.
Yeah, so tune in to that. You're going to get a lot more detailed information and get hopefully the assurances you want from that.
I understand E&O does not cover bodily injury. When can we expect the test cases of the agent being sued for the buyer or seller getting COVID?
COVID. Hey.
Yeah, back to COVID.
Back to COVID.
So some policies do cover bodily injury, but then some policies have a bacteria or viral exclusion. So again, go back and look. You know, these cases could come any day. You know, usually we don't see anybody getting hurt right away and then, you know, suing within a week. Usually it's months down the road, they get treated, they have to recover, they have to find an attorney, and then they have to find a way to support their claim that can show that we know we got COVID from this home during this showing at this time, and here's the source. So I do expect these cases to come about. When is anybody's guess. I'm thinking probably won't see them until next year. One, the Colorado courts are still shut down. There are no trials, at least until July. I expect that policy will be extended into August, maybe September. So right now, you know, people are not rushing down to the courthouse necessarily to file claims or lawsuits. Claims are still being filed. And we're trying to resolve those to avoid those delays because of the pandemic. But yeah, I think next year we'll start seeing those claims.
So a couple points of clarification. So a brokerage blanket policy is enough for the entire brokerage. Agents aren't required to carry their own E&O if the brokerage pays for their entire brokerage policy.
That's dependent on what kind of policy the brokerage firm has. There's umbrella policies which require that the individual broker have an individual policy, and then there's group policies which do not require the broker to have an individual policy. Sorry, Jim.
All right. Yeah.
Is there a septic disclosure we could give to buyers to answer common questions?
No, there is no statewide septic system form. And, you know, and Damien, I don't mean to speak for the forms committee, but I don't see how that would be possible because each jurisdiction does it different. And then there are also requirements from the state engineer. If the septic system is over like, what is it, 20,000 gallons per day, or maybe it's 2,000, I forget which.
2000.
So I don't see how there could ever be a form that could be readily used across the state. And this is just something that, you know, I would like to see as a point of emphasis in the annual updates and additional courses. So the last time I'm aware it was covered in an annual update was 2015, because I had a client who had a licensing complaint, and the question during the interview was, well, did you take the annual update course in 2015? He said yes. And of course there was slide 256 regarding septic systems.
Have you seen any difference in the results of a DORA investigation where the respondent is represented by legal counsel versus attempting to represent themselves?
Yes, I have. The way I see it is the broker tries to respond on their own, doesn't fully appreciate the significant or the extent of the problem. They make statements, they make admissions, they go in and give their interview, and then they realize based on the tone of the interview and the types of questions they're getting that, oh, this is way worse than I ever thought it was going to be. Now I need an attorney. And unfortunately, I can't go back and undo the interview or the statement or what was presented. And it's a lot harder to get those cases resolved. You know, the initial investigation, the initial response, when you get the, what we call, or used to call, the Rule E21 notice letter, that is your best opportunity to try and make that DORA licensing complaint go away. And I spend a lot of time on those responses to explain, to set the table as far as the context of the transaction, that my client is not a threat to the public. My client is actually a benefit to consumers. And we're going to use this as a learning opportunity. But a lot of times I see brokers like, I didn't do anything wrong, so I'm just going to send a one-page response. And then they get in, and then after an hour and a half being interviewed and grilled while it's being recorded, they realize, this is really a problem. I should go get an attorney. And then it's really hard for me to come in and try and fix things.
I think the most important thing you said there, Jim, as part of that is educating your clients and the brokers of understanding where they may have gone off the rails, and helping them understand what they could do better, which, you know, helps investigators feel better about it too when they realize the broker is owning that.
Right. And, you know, they also feel under attack and can get defensive during the interviews, and then that creates problems too, where they're not listening to what the investigator is trying to educate them on. So yeah, I understand it's a fine line of, really, do I need an attorney for this crazy person who just has it in for me and there's nothing here? But, you know, we got to appreciate that when DORA gets a complaint, they have to investigate the entire transaction. It's not just what you think the complaint's about or what even the complainant's about. They're going to be looking at everything. They're going to be looking, is your transaction file in order? Do you have E&O insurance? You know, was this form missing? Or why was there not an amend extend? Or why was the listing price left blank on the listing contract? So you may not appreciate exactly where the investigation could go. And that's what an attorney brings value to, because your attorney should be looking over a checklist of potential issues and be anticipating, okay, we don't know exactly where this investigation is aimed at, but we can see where it could possibly go.
Tying into the three-way reconciliation question, is there a program that you would recommend other than QuickBooks?
I really don't have a preference. I would recommend using an outside accounting or bookkeeping service that is familiar with what the commission requires. Okay.
There's a couple of products, and I can't remember off the top of my head, Jim. I'm sure you've come across them too, that actually specialize in doing this. But what I've heard, and maybe you've heard different, is that a lot of them still, you got to kind of figure out how to put the ledger in there, because they're not always geared exactly to what the rules are.
Right. Yeah, I don't know any software platforms that I can tick off right off the top of my head. You know, usually, you know, I get clients who have no accounting background, just like myself, and it's like, you really should outsource this and make sure you find somebody who is familiar with the regulatory requirements.
Would you recommend that one should be an agent for their principal, their buyer or seller, and then treat the other party as a customer?
Yeah, if that's the way it's going to work out, yes. But make sure you give out all the definitions, disclosures, everything's documented, that you're complying with the paperwork, and that you have a complete transaction file, and that you can show, you know, you did communicate, you did advise. as required. Damien, I don't know if you've got any additional thoughts on that.
I think I've beat it to death. I mean, obviously, I like agency customer. I think it's the best route to go when you don't have a relationship with one of the parties at all. Where it gets tricky is when you start having, oh, the seller is listed with you for 9 months, and then your sister wants to buy the property. And how do you go to a agent customer relationship, and who are you supposed to be an agent customer with, and how do you not? I mean, you got to use your best judgment when you're trying to represent people as far as what makes the most sense that you can talk to an investigator intelligently about and say, look, I was faced with bad options, in those situations, and I didn't know. So I evaluated it. I was transparent with my clients. I told them exactly what my options were. I gave them the opportunity to go somewhere else if they wanted to. But at the end of the day, they all want to be involved and they want to be a transaction broker. And to me, Jim, that seems the best way to defend these things, because there are instances where it's hard to figure out where you should be because of the relationships you have.
Right. And my understanding of why transaction brokers are allowed is because there is a demand. It does serve a benefit. It does reduce costs. And in theory, it should make things simpler and easier to convey property. But you just got to be careful, and you got to show that, you are walking that line.
All right. If a buyer you represented discovers defects after closing that they believe were known by the seller and were not disclosed, what's the best thing for me to advise the buyer? Should I correspond in any way with the listing agent, or can that muddy a potential lawsuit or mediation?
Okay. So I believe this is addressed in the form contract, Damien, about discovering or disclosing
I think
defects.
Aren't they talking about after closing though in this
Yes.
one? Okay.
Isn't there a provision in the form contract about disclosing defects after the transaction?
The only one in there that says is if it's after you go under contract, if you discover something during the course of the transaction, then the seller has an obligation to disclose. The only thing that I think survives after it goes to closing and is actually closed is going to be the mediation provision.
Okay. So yeah, that's, I think it's commission position with the last one, 46, about having a robust conversation with your client about doing disclosures. There, I would say you need to have the robust conversation. You as the broker, you only have a duty to disclose what you actually knew before the transaction closed. That's at least how I read the statute. I don't see the broker having a duty if they learn something after closing to disclose.
Jim, I think what they're asking is, what if the buyer finds out after closing, hey, this looks like something the seller didn't disclose? What's the buyer broker's responsibility / liability of trying to solve the problem after the fact?
Okay.
I'm sorry.
Well, the buyer's agent would have no, or should have no liability, because again, the buyer's agent is disclosing to their client all adverse material facts actually known at the time. So what you need to do is, okay, now this is a legal dispute between the buyer and the seller and maybe the seller's agent. Okay, so then you have to document that you advise your client to consult with an attorney. If they asked you for references, you followed the rule of 3 and gave them at least 3 names. And then they have to pick the attorney. And if that attorney calls you and wants the transaction file, it's always my advice, like, well, give a copy to the attorney, even though you already gave a copy to the buyer. Just facilitate them, and then, just be mindful that, because you owed fiduciary duties if you're acting as the buyer's agent to put your buyer's interest ahead of yours. So, cooperate where you can. If you feel like you are being attacked or targeted, then, you have no obligation to continue talking with their attorney. And you should alert your employing broker, counsel on retainer, and possibly even the insurance company that there's a potential for a claim. Okay. So a lot of times though, I'll get brokers ask like, so I gave them my transaction file. Now they want my emails. Now they want my notes. Now they want the text messages. Do I have to give that to them? And it's a case-by-case analysis. Like, well, what's in those emails? What's in those texts? Are they going to help clear your name, avoid you being suspected of doing anything wrong? Then I'll say, go ahead and give it to them. If it's questionable, then it's like, well, we got to look exactly what they're asking for and how this is going to play out. The regulations, the rules from the commission don't require that you provide or keep as part of your transaction file emails, text messages. But we got to look at it case by case. What's going to be in your best interest? I have clients who, want to tape record conversations. I don't recommend that. It looks bad before a jury and a judge that you're secretly recording conversations. And, you might be saying, yeah. And, that could be interpreted as, well, you're admitting fault. You're agreeing that you're going to fix this. And then your insurance company gets involved and like, no, we're not going to do that. And so then you're playing off against your insurance company. So I really don't recommend recording conversations with clients. As an attorney, I cannot do that. Ethically, it's prohibited. But, just be very careful. If you think your client could go south on you, then be prepared to have a plan of action.
This is kind of a fun one. So this broker says, I had a client purchase a 6-unit, 2 buildings, 3 units each, on the same lot, that after a few months after purchasing it, the city told the new owner it needed to be converted back to 2 duplexes. The property had been a 6-unit for years and even sold to the previous owner in this status. CoreLogic showed it as a duplex, triplex, while I represented the buyer, and it passed title and lender underwriting as a 6-unit. Who is ultimately responsible? The seller, listing agent, title insurance, me as the buyer's agent? Who gets to pay for that one?
That's a great question. And it'd probably take a trial to figure that out. I don't know, to be honest with you. That's a complicated fact pattern. I have not had that case, I can tell you that. I've had the case with the mother-in-law unit being declared an illegal auxiliary dwelling unit. And those are painful to deal with, especially with Boulder County, among other jurisdictions. So that's a great question. My advice would be consult with an attorney, and get an opinion once that attorney can look at all the facts, the entire history of what's going on and what exactly is being claimed and who knew what and when did they know it.
We've kind of had this question before, but this broker took it kind of a step further that I think is interesting. So if a property is stigmatized, losing potential significant value because of a rodent, termite, past issue, can the buyer go against the seller? And if the current seller says that they had no knowledge of that, can you go back even further?
That's a good question. First of all, a rodent-infested property, I would not classify as stigmatized. Stigmatized has a special meaning in the law. I associate with the psychologically impacted property statute. Yes, there could be stigmatized in that all the neighbors know, oh, that's the rat house. Don't go near that, or don't let your kids play around that house. But, you know, the problem is with the statute of limitations, yeah, if you can go back and show that the seller didn't disclose it to you, that you didn't know, then possibly that seller may have a claim, or the seller who's now the buyer may have a claim against the party that sold them the property. I've never seen the cases go back that far. I have seen it where the seller did make renovations and then it became like a construction defect case where the seller was going after their contractors and subs. So, you know, when you get into these cases, you just never know where they're going to go with these issues. But yeah, that would be one of the questions I would be asking about. What's the liability of the predecessor before? Why didn't they disclose? Especially if it's in a short time frame. Like I had a case up in Lyons where these people only owned the property for literally less than 3 months. Okay, and their buyer sued them for lack of permits, lack of zoning compliance with the local FEMA flood zoning and non-disclosure. Like, well, their seller, like 4 months before, did not disclose any of that. So yeah, there's potential liability for the initial seller and that seller's agent too.
All right, I'm going to grab one more question here. I know we kind of went super over time, but there were so many great questions. I'm sorry we didn't get to them all. So we'll end on this one. As I understand the rules of the escrow, fiduciary, trust accounts, they must be accounts that can't be accessed in the case of a lawsuit. You mentioned that. Most bank accounts are not this, so just an account called trust is not the correct account. Correct? I've been trying to find a bank that will open a true escrow account and have not been successful.
I will tell you the one that I know is First Bank. I know that they open trust accounts, at least for brokerage firms. What also might be helpful is if you have a copy of the Rule 511 to be able to take down to the bank to show them that you guys have this requirement for security deposits, which might make them more apt to open the account. Jim, have you run into any of this or?
Yeah, so I know up in the mountain communities, Alpine Bank is good at working with brokerages and brokers and setting up compliant trust and escrow accounts. Yeah, First Bank, you've mentioned that, I believe, in the past to me as well. But yeah, I would hope that, you know, because attorneys, we have to have what's called COLTAF accounts, which are basically trust accounts, the same as you. And so, you know, like for instance, my law firm, our COLTAF account is with US Bank. So, you know, I would hope that if you walked into US Bank and talked with the banker and showed them the regulations, they would get it and understand. But, you know, I don't have a list that I can specifically refer you to, though.
Yeah, maybe starting with the COLTAF banks might be a way to get there.
Yeah.
Okay, great. All right. Well, thank you again so much, Jim, for being on today. Thanks, Damien, as always, for being our staple each week. Thanks, everybody, for joining us. It was great to have you. I hope you got a lot of value out of today. I will send a follow-up email with the recording of today's session, and I'll include some follow-up items. I saw some requests coming through, so I'll include that as well. Thanks so much again for spending this hour and a half with us, and we hope to see you on the next industry update.
All right. Well, thank you for having me. Everybody stay safe.
All right. See ya.